Well, it is right at 11:30, so we're going to go ahead and get started with this webinar today. It is going to be pretty informal. I don't have slides done for today. We're just going to kind of talk about incapacity, but we'll wait just another second to make sure nobody else joins us. But it is going to be informal today. We're just going to talk about incapacity, how to prepare for it, and what things we can do to plan ahead so our families don't end up in hard positions. Well, I'm Lauren Ward. I'm an attorney with a business law firm in Spartanburg, South Carolina, and my primary focuses of practice are estate planning, probate, and business law. So with that in mind, we will go ahead and start on this program today. So this program is based on incapacity and who is going to speak for me. Well, if you become incapacitated and you don't have documents in place, a court could probably determine who is actually going to speak for you. So we want to talk about what to prepare for ahead of time so your family doesn't have to go through a hard court proceeding or process. So with incapacity, there's two types of powers of attorney we need to think about. One is a healthcare power of attorney, and this allows somebody to make medical decisions if you are unable to make them for yourself. With a healthcare power of attorney, you can appoint an agent, and I recommend appointing backups as well or contingent agents. So if the primary one is unable to fulfill their duties, you've already got contingents. So in case something happened, like for instance, a lot of times a husband and wife will put each other as contingents, each other as primaries, but they're in a car wreck together. So it's important they have those contingents because both of them could be incapacitated. Our healthcare power of attorney in South Carolina is typically a statutory form in that we have what's known as the living will. In this document, you can make decisions on organ donation. So you can decide if you want to be an organ donor or you do not want to be an organ donor. You also can decide how you want to handle life support and feeding tubes. So in those end of life decisions, there's three options. One is to let your agent make the decision. So you're not making a decision today. You're holding this out for the future for your agent to make the decision. Two is to say, I do not want a feeding tube or I do not want life support if it is end of life and this is what is keeping me alive. And three is for maximum treatment. So you get to make those decisions while you're doing this document. It is important to make sure you thoroughly think these through. Once you've signed and had your healthcare power of attorney properly witnessed, you will need to keep it in a safe place. I usually recommend, having a copy on you when you travel, recommending even putting a digital copy on your phone if something were to happen and giving a copy to your agents. You also can give a copy to your primary care physician. And if they're part of something like Spartanburg Regional System or Prisma System, they can put it in your My Chart so that way it shows up for all the other physicians to see or would show up in the emergency room. So with this healthcare power of attorney, it is important to make sure that you have this done before you are incapacitated. If you wait too late, you won't have capacity to do this. So once you get it done, put it in that safe place. You can always keep a copy on your phone or keep copies with your kids or whoever you're leaving as your agents. One tip when picking an agent, it needs to be somebody that can handle making decisions in a crisis. Healthcare decisions usually have to be made pretty quick. So it's important when you pick that power of attorney to have someone that can make those decisions in a crisis. And I usually say talk to them once you've picked them as your agent and make sure they know what you would want. You don't want to have somebody that would prolong your life if that is not what you're wanting. If you don't want to have certain procedures, you want to make sure your agent knows this and does what is right for you. So that's on the medical side of things. That's our healthcare power of attorney. But if we're incapacitated, we also need somebody to help with our finances. Your mortgage still has to be paid. Your water bill still has to be paid, or they'll turn those things off or foreclose on your house. So we have what's known as a financial power of attorney, and this allows someone to make decisions for you as well. With this, I usually recommend the same thing, having your primary, but also having contingents. So if something happens, you do already have those backups in place and you don't have to come redo this document. When doing your power of attorney, you want to think about things like, do you want to allow your power of attorney to make gifts? A lot of people, regularly give to charity. And so they want to make sure their agent can continue, to make those donations to their church or to their alma mater or to one of their charities of their choice. It also can be important if in the future you may need Medicaid to have this gifting power, so that way your family could possibly put into place some type of Medicaid plan. You also can have the power to sell real estate in your power of attorney. Most of the time, most people want a pretty broad power of attorney, so that way their agent can do anything for them that they could do themselves, so that way they don't have to go to a conservatorship in front of the probate judge. So with the power of attorney, there's different ways this financial power of attorney can be set up. There is one where it can be set up as a durable power of attorney, which means it survives incapacity. What this means is it is valid the day you sign it, and if you become incapacitated, it's still valid. That means the person could technically act for you, your primary agent could act for you when you sign it. Then there's this one known as springing. This means that it only comes into play if you are incapacitated. With this thought process in mind, usually a doctor has to declare you incompetent for that springing power of attorney to work. It is a personal choice of what you want. A lot of times, I think in my situation, I've used the durable power of attorney that survives incapacity. I trust my husband now. I'm going to trust him if I'm incapacitated. And it makes it easier that doctors don't have to be involved to have somebody declared incompetent or incapacitated, and banks usually accept it a little bit easier. With that in mind, the power of attorney in South Carolina is valid when you sign it. But if you do become incapacitated, it has to be recorded with the Register of Deeds in the county in which you live, or the county in which you own property. So if you live here in Spartanburg, but also have a house down at Beaufort, you're probably going to record it both places since you own property in Beaufort. With the recording, it requires 2 witnesses and a notary. I tend to err on the side of going ahead and recording it now and not putting that burden on your children, because recording requirements can change. Our notary block can change. Those type things happen. And sometimes it can be hard to record a document 20 years later. If you do record the document, it is public record because it is recorded with the Register of Deeds, the same place your deed is recorded. If you decide not to record that power of attorney, you better keep the original in a really safe place, because when it needs to be recorded in the future, you're going to have the original. Once the document is recorded, though, if you lose it, you can always get certified copies from the Register of Deeds. But that is a choice you as the client would make if you would like your document recorded or not. And you can make the choice if you would like it to be springing or not, and depend on your incapacity. So a power of attorney is a little more complex than a lot of people think, and it's good to know what your options are inside of it instead of just downloading it online and just checking some boxes. It's really important because a power of attorney is honestly more important than your estate plan in many ways, because this is to deal with you while you are still alive. It's not just your assets. It's about your care, your well-being, making sure you're taken care of, having somebody to be able to pay those bills. So if you do need nursing home care or in-home care, somebody can access your finances to be able to do this. I recommend a power of attorney for anybody 18 and older. We do not know what tomorrow holds. None of us are guaranteed a happy and healthy tomorrow. So we always want to have that power of attorney. Once we're 18, we're legal adults. Our parents can't make decisions for us. So going ahead and having those powers of attorney in place. It's also important a lot of times for kids to do this before going off to college. So that way, if they're nervous and don't want to talk to the doctor, they can still have mom or dad call. Or if, something happens and they're in an accident and the family needs to talk to the school and those type things, that power of attorney is really important to have in place. So to sign a power of attorney, a financial power of attorney, you have to have contractual capacity. This is a higher bar than capacity for signing a will. For a will, it's testamentary capacity. You just have to know what your stuff is and who you want to give it to. But with contractual capacity, you actually need to understand what is going on in this power of attorney. So it's important you do this during a time when you are mentally competent to do so. If you sign a power of attorney and you probably didn't have capacity to do so, people can go, maybe you didn't list your kids as your powers of attorney. Well, they can possibly go and have this power of attorney undone by the court because you shouldn't have been able to sign it because you didn't have capacity. So it's really important you do this while you are mentally competent. Do not wait until there's issues of capacity. You know, you may be the brightest, sharpest 90-year-old, but at 90, a court's going to look at it and go, did they truly have capacity? So it is important to make sure you do this while you have mental capacity. If you don't do these documents, let's talk about what would happen. If you do not have powers of attorney and your bills still have to be paid, or somebody has to make medical decisions for you, typically you're going to go through a process known as a guardianship or conservatorship. You do this the county in which you reside, and it is through the probate court. With this process, the person petitioning typically has an attorney, the alleged incapacitated person needs an attorney, and a lot of times there is another person involved known as a guardian ad litem. They are appointed to make sure that the best interest of the possibly incapacitated person is followed through with, and they're there for the best interest. So you have three different attorneys typically on the case at that point. You also have to have a medical expert involved. You have to have what's known as a doctor do an examiner's report. And in this, the doctor has to say whether they think this person is incapacitated or not. The court is going to rely heavily on this document because you have to see, the court has to have some medical guidance knowing if this person is truly incapacitated. If you are applying for conservatorship, you're going to need to tell the court what the assets are. Maybe you don't know them yet. Maybe once you get appointed conservator, you know, but you have to tell the assets, and you're going to have to get bonded a lot of times based on the size of the estate. In Spartanburg County, our judges typically do require bonds, which can be kind of expensive. So it's important, you know, to have those powers of attorney so your family's not going through this. But with this in mind, going through the proceeding for guardianship, conservatorship, once all the paperwork is submitted, the petitions, the examiner's report, you have to have a hearing in front of the judge. And the judge ultimately decides if you need a guardian and if the person wanting to be your guardian is competent to do so. That person has to usually give SLED background checks, credit reports to the judge, and the guardian ad litem also has to interview and meet with this person. So with that in mind, it is a pretty much a trial process. There are witnesses called, testimony is given, and ultimately the judge makes the decision. If you are appointed guardian, you have to provide a care plan to the courts to show what your plans are for taking care of this person. If you are appointed conservator, you have to have an inventory and appraisement submitted, and that is usually how they're going to base the bond on the size of the assets and have you submit the bond, which is just an insurance policy pretty much that if you absconded with the money, the court's protected. And then you're going to need to meet with the court every year, and you're going to need the court's permission to spend this money. So having to go through these guardianships and conservatorships are a lot of expense, not just in attorney's fees, but also you're paying bond fees, you're paying court fees. It is a lot more complicated process than just having those powers of attorney done. And you know, when you do the powers of attorney, you get to pick who you want to act for you. When it's a guardianship or conservatorship, if multiple people are asking, it's ultimately up to the judge. Where when you're doing the documents yourself, you're in control and you have power. So it is important while you have mental capacity to get those powers of attorney done. Going through guardianships and conservatorships are a lot more expensive, a lot more headache, and it is so much easier for your family to just go ahead and do those. So while nobody wants to really plan for incapacity or think about it, it is important to make sure you've got these in place to protect yourself and to protect your family. If you have questions about those or want to help set one up or want to meet with us to discuss that, please feel free to reach out to us at A Business Law Firm. Once again, I'm Lauren Ward. You can feel free to give us a call at 864-699-9801, and we will be happy to walk you through this process and help you get those documents drafted so you can have peace of mind and your family can have peace of mind. We thank you for joining us today. We're going to upload this to our YouTube channel. If you want to share it with any of your friends, family, clients, or anyone, feel free to do so. But we are glad you are a part of this, and feel free to sign up to get links to more webinars in the future, as my law partner Chelsea will do some in the future, and we'll continue to do these. And we do send out blogs from time to time. So please feel free to join any of that. And please feel free to give us a call at A Business Law Firm, 864-699-9801. Thank you for joining us today, and we look forward to helping you in the future.